कोल्हापूर जिल्हा बार असोसिएशनतर्फे आज डिफरन्स बिटवीन ट्रायल कोर्ट अँड हायकोर्ट प्रॅक्टिस अँड प्रोसिजर याचं व्याख्यान आयोजन केलेलं आहे. आजच्या कार्यक्रमाचे अध्यक्ष व्ही आर पाटील साहेब, उपाध्यक्ष पाडेकर साहेब आणि व्याख्यानासाठी आलेले आपले कोल्हापूरचे सुपुत्र ॲडव्होकेट अनिल यशवंत साखरे साहेब, माजी न्यायमूर्ती मान्य नामदार मुंबई उच्च न्यायालय मुंबई साहेबांची ओळख करून द्यायची म्हटलं तर सगळ्यांना परिचित आहेत. कोल्हापुरात त्यांचं एज्युकेशन झालेलं आहे. कोल्हापूर जिल्हा बार असोसिएशनचे सिनियर सदस्य त्यांचे वर्गमित्र आहेत. तसेच अनिल साखरे साहेबांचे वडील कोल्हापूर जिल्हा बार असोसिएशनचे माजी अध्यक्ष आहेत. त्यांचे भाऊसुद्धा आपल्याकडे इथं कोल्हापूर जिल्हा बार असोसिएशनमध्ये सन्मानित सदस्य असून ज्येष्ठ आपले मार्गदर्शक असून आपल्या इथं वकिली व्यवसाय करतात. मुंबई उच्च न्यायालयात बरेच वर्ष काम केलेलं आहे, न्यायमूर्ती म्हणून काम केलेलं आहे. तसेच मुंबईतील मोठे मोठे पॉलिटिशियन यांचंसुद्धा साहेबांनी त्यांच्यामार्फत काम चालवलं आहे. असे आपल्याला आज लाभलेले आपले व्याख्यानासाठी ॲडव्होकेट अनिल यशवंत साखरे साहेब. मी अध्यक्ष साहेबांना विनंती करतो की त्यांनी अनिल यशवंत साखरे साहेबांचं स्वागत करावं. आजचं ज्या व्याख्यानाची गर्दी पाहता आपण एक नंबर वकील कक्षामध्ये स्क्रीनची सोय केलेली आहे. तिथली परिस्थिती माहीत नाही, आपल्या इथे फुल आहे तिथं कशी आहे परिस्थिती माहीत नाही. ज्यांना जिथं जागा मिळेल तिथं आपण ते लाईव्ह आपण बघावं किंवा जे काही सोय असेल तशी. त्यानंतर मी आजच्या आपल्या प्रमुख व्याख्याते जे आहेत ॲडव्होकेट अनिल यशवंत साखरे साहेबांना विनंती करतो की त्यांनी आपलं व्याख्यान चालू करावं.
Honorable President, Honorable Office Bearers of this association, and my friends. Today's topic is regarding difference between trial court advocacy and high court advocacy. For trial court advocacy, I will little bit explain, and then I will explain about the High Court advocacy and what is High Court appellate side, what are the powers of the High Court judges, and how we should prepare and present our cases. For the trial practice, young law students who aspire for career in litigation always want to know what is the difference between practicing at the trial court and practicing at the appellate court. As we know, trial court is a court of original jurisdiction. Word trial is not defined, but it is understood. The meaning is very clear. It is a judicial examination of evidence, which may be of many kinds, like documentary, oral, circumstantial, or even now electronic. Trial generally starts with completion of pleadings and framing of the issues, and in criminal it starts with the framing of the charge. I will little bit go in detail regarding what is a trial advocacy, because both are very important For to be a trial advocate and to be a successful appellate side advocate, High Court appellate side advocate, experience of the trial court will benefit the advocates who wants to practice at the appellate side of the High Court. Legal profession is one of the cornerstone of the functioning of the democracy, ensuring that the justice is served and the rule of law is upheld within a vast framework. The trial court advocate holds particularly very pivotal role despite their significance. The importance of trial court advocates is often understated, leading to misconception about their impact in judicial proceedings. Trial court advocate requires drafting evidence. He must know Evidence Act very well. He must know Procedural Act very well. Then he can present his case and he can represent his client successfully. The appellate court or High Court appellate side practice is totally different and distinctive. The appellate side advocate do not have concern themselves with what kind of evidence will lay. Appellate court is meant for further opportunity to the aggrieved party, aggrieved litigant, who has lost before the court of original jurisdiction, that is trial courts. In civil procedure code, various provisions are made where litigant, aggrieved litigant can file proceedings in the High Court, such as first appeal, second appeal, civil revision applications, appeal from orders, miscellaneous application, and mainly rate petitions regarding 2 to 7, which I will elaborate in detail, because that is a very major practice which advocate has to conduct in his day-to-day practicing before the High Court. The Civil Procedure Code has provided second appeal. Civil Procedure Code has provided CRA, that is under section 115. Then appeal from orders are provided. There are miscellaneous orders which are challenged in the High Court. There are orders, final orders which are challenged in the High Court. In appellate court advocacy, usually only aggrieved party has to take much pain to try and reverse the finding of the trial court. And so the first question in most matters is, what is the error committed by the trial court? Where the trial court has gone wrong and in what manner? What is the discussion on the issue in the judgment? The appellate court advocate has to point out errors, mistakes committed by the trial court advocate, trial court judge in giving his judgment, where the judge has committed error and where that error is question of law or appreciation of evidence. However, even if High Court advocacy is to point out faults in the judgment, one is required to see the entire record and proceedings of the trial court. As without examining the record, one can't reach to the conclusion as to how it is wrong. There is an element of practicing in High Court which is absent in the trial court, that is constitutional practice. In trial court, procedure is governed by the Civil Procedure Code, Evidence Act, civil manuals, and directions given by the High Court from time to time. But High Court appellate side also has a constitutional law practice which is very important practice at the High Court stage. The trial court advocate may not be aware what are the powers of the High Court and under which article of the Constitution it is exercised. High Court can issue 5 types of writs Writ is command. One is mandamus, second is certiorari, third is quo warranto, fourth is habeas corpus, and fifth is prohibition. With these 5 writs, the High Court can issue command on legislative actions, executive actions, subordinate courts actions, and even the authorities who are state within the meaning of Article 12. Each one of the above writ can be issued in specific cases, and this power of writ has to be exercised by the High Court for protection of rights and for enforcement of the fundamental duties. As an advocate appearing in the High Court, major work and important work is constitutional matters, which we say that it's a writ petition. Generally, disputed questions of facts are not gone into the writ jurisdiction. But writ jurisdiction of the High Court is unfettered. There are no limits, but there are self-imposed restrictions by passage of time from judgments of the Supreme Court and High Courts, that in what circumstances writ can be entertained and writ can be issued against the government, against the police authorities, against the states, that is Article 12. This I will give that in detail what is Article 12 when we come to the Constitution. Supreme Court exercise power of issuance of writ under Article 32. But that power is limited to the protection and preservation of fundamental rights and protection and preservation of statutory rights and or enforcement of statutory duties may be necessarily fall within the ambit of extraordinary jurisdiction of the Supreme Court under Article 32. As I am under the Supreme Court, law declared by the Supreme Court is binding on all courts within the India, so also binding on the governments. Under Article 142, Supreme Court can mandate and to limited extent legislate. When I say legislate, means you must have come across in the COVID period. Limitation period was extended. Directions were given not to take actions of demolitions. All this is under Article 142, which the Supreme Court did. But for High Court platform is much wider. Even the Supreme Court is supreme, but all litigation of fundamental rights, the constitutional rights, etc. are resolved in the High Court in a maximum way. Very few cases reach to the Supreme Court. Therefore, apart from criminal law or civil law, I will say 70-80% of cases are writ matters, where writ are under Article 2 to 6 or Article 2 to 7. Article 2 to 6 and 2 to 7, there is a vast difference in exercise of power. As I told you earlier, civil litigation or criminal litigation coming from the lower judiciary can be summarized, for civil matters can be summarized as a first appeal against the decree passed by the trial court, final judgment and decree passed by the trial court, depending upon the jurisdiction, pecuniary jurisdiction of the court. First appeal lies to the High Court. So also many cases from junior division judge, appeal lies to the district judge. These appeals are on facts and law. What is the meaning of facts and law? The appellate court can reassess the evidence and can come to the conclusion whether the trial judge was right or wrong on facts and in law. But there are certain judgments, a view which Supreme Court has taken, High Court has taken, that a trial judge has an opportunity to see the demeanor of the witnesses, and that view is possible. And being an appellate court, we are having different view. That doesn't permit you to interfere because trial court has taken a view which is a possible view. So while considering the appellate practice, you have to consider whether that view or judgment given by the trial court is in accordance with facts, in accordance with law, and make a submission in the first appeal. But as the first appeal being a fact is on the facts and in law, generally first appeals are admitted. When I say admitted, means there is a procedure and the appellate side rules framed by the High Court that each and every case comes for admission, and after case is admitted, it is listed for final hearing. So as per our experience or my experience, 60-70 cases are disposed of at the admission stage itself. And admission is a skill because you get a limited time, and within that limited time you have to persuade the judge or convey the judge what are the issues involved and why it requires a consideration by the higher court, that is first appellate court. Then we come to second appeal. That is a major litigation in civil, I will say true, because it is a first appeal is decided by the district judge, and again that second appeal comes to the High Court. Scope of second appeal under section 100 is limited. It says that only question of law which has been formulated by the judge has to be addressed at the final hearing. So my experience is, I have completed 49 years of practice. The second appeal is very tough to argue because after reading 200 pages to find out some error, and that to fit it in the substantial question of law, and what is a substantial question of law is also defined by the Supreme Court. If that test is to be applied of the Supreme Court, it is extreme view taken, not followed by High Court judges normally. If that extreme view is taken, then second appeal will not be maintainable at all. But this is for admission, it's a seriously argued issue. Second appeals are very vehemently argued in the High Court because that admission and framing question of law for an advocate is also very not difficult, but it's not easy job. So also for the court to formulate the question in his order and say that this question of law is arriving in this case, and therefore I admit this appeal, because final disposal of that case will depend upon that question of law. Then CRA, Civil Division Applications under 115. Previously, 10-15 years back, again the interim orders we used to file civil division applications, like framing of the issues, appointment of court commissioner, grant of injunction, refusal of grant of injunction, where one miscellaneous appeal is in the district court and you come by way of revision application. But by judicial pronouncement it was held that this revision applications is not maintainable against the interim orders. Therefore we started filing it under Article 227 of the Constitution of India. It's a major work as far as juniors are concerned. Interim application, interim orders which are challenged in the High Court, generally list is not decided. For taking a case, that injunction application, trial court decides, appeal court decides, again that you come in the High Court. But finally it is not there, therefore juniors have good chance, get too much practice in that. That is my experience, because all juniors have that work. Generally after second appeal is filed, first appeal is filed, writs are filed, the litigants or instructing advocates prefer medium advocate who has practiced more, who is senior, etc., etc. Then there is an appeal from order. Appeal from order is order 43 rule 1. Suppose suits are tried by the civil judge Senior Division, appeal from order lies to the High Court, and that is a regular miscellaneous appeal before the High Court. It is arising out of miscellaneous orders passed by the civil judge Senior Division, mainly injunction matters, court receiver matters. These are generally cases arising out of a civil trial, which High Court appellate side advocate have to deal with. One is first appeal, very easy to handle. Second is second appeal, very tough to handle. Third is CRE. Fourth is AO, appeal from order. These are interim orders. Nothing much depends upon that in the trial of the case. But there is one more important jurisdiction of the High Court under Article 227, which has major part of practice. Even one or two judges will not be sufficient for admission work itself. In Bombay, 4-5 judges take this admission or 227. 227, I was also not knowing that there were so many tribunals which are under 227. One is industrial court. Orders passed by labor court, industrial courts are challenged in this jurisdiction under Article 227. Then family court. That is the first appeal. Interim orders are challenged by way of writ petitions. Then cyber related telecom dispute settlement and appellate tribunal. This is a new branch. The cyber related cases. Again the decision of the tribunal, writ is maintainable the High Court appellate side. Then motor accident claims tribunal. There is a first appeal provided under the Act, and interim orders, writ petition is maintainable. Then there will be major work, if I may say so, is regarding income tax appellate tribunal. So your assessment is decided by the assessing authority. Again that there is appeal provided to the tribunal. It is a faceless tribunal. What is meaning of faceless tribunal? You don't know who is hearing your matter, who is hearing your reference or appeal. Link is provided to the advocate practicing at income tax mainly. They appear in the tribunals. Link is provided half an hour prior to the case which is scheduled. Suppose your case is scheduled at 1:30, at 1 o'clock you will receive your link on your mobile and you have to log in that. Your screen is blank, but judge whose tribunal you must be arguing in from Mumbai, the tribunal must be in Madras or tribunal may be in Calcutta. So it is called faceless tribunal. There are no queries made. We don't know before who I am appearing. Maybe government do not want it that there should be interaction between the assessee litigants and these tribunal members, maybe. But that is appeal. What you do is, whatever you have prepared from A to J, you argue and finish. Because there is no query asked, time limit, there is no restriction, and at the end you can say that tribunal, sir, I will circulate my written judgments, whatever I argued. That is faceless tribunal. Time will come for us also, because of technology. Faceless tribunals will be, now you can appear from Pune, Kolhapur, Sangli, Satara in High Court. As we appear from Supreme Court, we appear in other High Courts, Nagpur, Aurangabad, from Mumbai only. We don't have to travel, because it's in COVID period has given us too much experience as to how to handle cases. Then there is a Maharashtra Administrative Tribunal, a major litigation of civil service. All government services, like collector, revenue, whatever the government servants are, their cases are tried in the Maharashtra Administrative Tribunal. That Maharashtra Administrative Tribunal is generally presided over by chairman is retired High Court judge. At present, Mr. Mangesh Patil judge is the chairman of the tribunal. So again that division, writ lies to the division bench. That is two judges taking that matter. But that is a major litigation. A service matter is a major litigation nowadays, because I have opportunity to attend one function at the administrative tribunal. One advocate while lecturing said that we wait for June because entire bunch of litigation of transfer matters are coming and we survive for 1 year thereafter. So that is a very heavy practice because High Court I am giving you, you can't confine yourself to the Civil Procedure Code or Evidence Act. You have to broaden your vision. You have to learn what is service law, what is tax law, what is industrial law, because under one umbrella you are practicing. Today judge may be taking civil matters second appeal. After 4 weeks he will be taking these MRT matters, these tenancy matters. Another judge will be taking criminal, will come for civil. So likewise what I have seen is appellate side practice, advocate has to equip with all branches. Trial court there is segregation. I practice on criminal side, I practice on civil side. Civil advocate will say that I don't go to criminal, criminal will say that I don't go to civil. But no, appellate side you have to go everywhere. And after 15-20 years you can select which branch you have to follow, in which you are successful, where you are comfortable, and your own thinking that I am happy with civil, I am happy with criminal, so I will pursue it. That's how me, I was having very heavy criminal practice also, but after some time I decided that civil is good for me. So I decided and I developed my practice at civil side. And civil side is a ocean. There are no limitations on your practice. You go in any branch, there is a voluminous work for advocates. Criminal, now there are BOFA, there is ED is coming, other offences are coming, there criminal advocates are also happy. So their field is also expanding. Cyber crimes are coming, new offences are coming which Indian Penal Code doesn't provide. Indian Penal Code mainly talks about body offences and some 420 or something, cheating, beating, etc. But these are new offences coming, cyber crimes, etc., where even criminal law advocate has to study various branches of law within that criminal side. Then there is a writ petition against the debt recovery tribunal. That is also major litigation because all civil suits one day were transferred to the debt tribunal. Debt tribunal, DRT we call it, decide that court cases, bank cases, again that appeal is provided to DRT, then again that High Court. So generally person who has taken a loan has a capacity to fight till High Court. So that is also good work which you must know. DRT procedure also you must know, those who are wants to practice at the appellate side. So every month you will get industrial law case, you will get some tenancy case, you will get ceiling cases, you will get DRT cases, you don't know. You have to be comfortable in all branches of law. Then Maharashtra State Cooperative Code, as everybody knows, Kolhapur has a lot of litigation of cooperative. So writ petition lies against the appellate court to the High Court. That is also major litigation in a appellate side. We call it cooperative litigation in writ jurisdiction. Then there is custom, excise and service tax appellate tribunal. So custom cases, excise cases and GST cases are tried by first authority, appeal goes to the tribunal, and again that tribunal judgment writ comes to the High Court. That is also in some part in Pune, etc. is a major litigation. I don't know about Kolhapur, but where there is a commercial activity or industrial townships are established, there this litigation is good for advocates, and that is a separate branch itself. Then there is one more tribunal which has come now, Intellectual Property Appellate Tribunal. So I have not seen that. I was told by my junior yesterday only that there is one tribunal called Intellectual Property Tribunal. I have not come across, but in future these intellectual property rights matters are going to arise, and we have to cope up. And then there are cases. In Kolhapur I don't know, but in Pune and Mumbai there are cases under the Slum Act. One judge is required to hear, one division bench is required to hear slum matters, because slum tribunals, there is slum authority, against that there is a appellate tribunal, and against that high court matter is taken in high court. Daily 50-60 new cases are before the courts and they are not able to cope up. Same, there is litigation against the MHADA. MHADA means Maharashtra Housing and Area Development Corporation. Then there are litigations against the municipal corporations and municipal councils, because they are not governed by the service tribunals. So any person having some issue, suppose in Kolhapur Municipal Corporation, somebody has a grievance of his transfer, promotion or punishment in the departmental inquiry, his only remedy is to go to High Court and get the redress, whatever he wants to get the justice from the Honorable High Court. So these are the broadly civil litigation and writ jurisdiction of the High Court. And when I say that writ jurisdiction is vast, you must have now understood that there are 12 or 13 tribunals which comes under the High Court and the Article 226 and 227. So this is a litigation which you will have to adopt. For that, you will have to see what are the basic things. You must know industrial law basic, you must know family law, you must know this accident claims tribunal, service law. Then DRT is nothing, and I find that there is nothing too extreme. Your basics in civil law are clear. You must have mastery on civil procedure. Mastery in the sense you must know basic provisions of CPC, Evidence Act, Contract Act, Transfer of Property Act, Sale of Goods Act, and this bank related mortgage, transfer of related mortgage, etc. This you know, then you can practice in this DRT, etc. There is not much difference. In DRT, matters are not, evidence is not recorded. It is tried on the basis of affidavits filed. When I come to writ jurisdiction, I will give that reference, what is the difference in civil suits and what is the difference in Article 226. And what are the differences which advocate has to keep it in mind while presenting their case under Article 226 and Article 227. Coming to the writ jurisdiction. Before we go to writ jurisdiction, we take it that in the law college we have studied the Constitution. That is a basic document for democracy. And on the basis of Constitution of India, all laws are framed. And therefore you must, as a practicing advocate at the High Court, either original side or appellate side, you must know Constitution very well. Original side, when I say there are only 3 courts which had original side, that is Calcutta, Bombay and Chennai, Madras, because they were established somewhere in 1764. And Queen of England gave that authority by latest Patent Act of 1865 to exercise writ jurisdiction. And that's how the original side and appellate side is there, but other courts like Karnataka, Madhya Pradesh, etc. There are no, only there are 3 courts which are original side courts, which High Court has original sides. Other High Courts have only appellate side. When I say the Constitution, you must know, because you can have to start. One day you have to argue these cases. And there are very few articles which you know, you must know. And there is a lot of debate for last 30-40 years on these articles. Briefly I will give which are relevant for your purpose to start a practice with. Article 12. Article 12 is a government and statutory bodies discharging public functions. So which are these statutory bodies? just like Municipal Corporation constituted under the Maharashtra Municipal Corporation Act, municipalities which are constituted under Municipalities Act, Jilla Parishad under Jilla Parishad Act, various MIDC under MIDC Act, then there is MSCDCL under the MSCB, old MSCB, now is MSCDCL. These are all statutory bodies and they discharge public functions. So when I say Article 12, writ can be issued only to a government or a authority or statutory body discharging public duties. That is Article 12. If the question will be, it was debated long ago, whether writ can be issued against the cooperative banks. There is a full bench judgment of Mrs. Justice Sujata Manohar in, I think, Saraswat Bank's case, where full bench said banks do not perform public duties, cooperative banks. These are political, I take it lightly, it's a political field, and therefore writs are not maintainable. Therefore, when you practice in High Court, you must know against which authority I can go in the High Court directly. I will, word of cautious, any matter can be taken in High Court in jurisdiction, any matter. But High Court will say that, all right, Mr. Your client can file suit. Why you are not filing suit? You can say, sir, my client is 99 years old. Till her case is decided, she will not be alive. Court may have sympathy, will say that, all right, I will try your case. Others they will say that go to regular forum. And giving you, there are self-imposed restriction on High Court. Limitation Act is not applicable, Evidence Act is not applicable, no procedural law is applicable. It's a free hand to the litigant whose fundamental rights are violated. And I will give you cases you must read, who wants to practice, and the writ jurisdiction, what is that writ jurisdiction means. So Article 12, writ is maintainable in the state. Then Article 13 is equality. Article 14 is very important article for the purposes of in a democracy for our citizens, and we practice as advocate. We always say that there is a violation of Article 14. What that Article 14 is? Article 14 tells that everybody should be treated equally in regard to caste, creed, male or female. They are one in eye of law. Because you are son of some minister, you should not be given special treatment, and because you are son of pure, you should not be deprived of your constitutional rights. That's how Article 14 is. Major work or major judicial time has been wasted in saying what is Article 14 and how it affects us. When we go to the court, we say that, all right, sir, I am completed 5 years, he has completed 5 years, he is promoted, I am not promoted. He is favored, I am deprived of my right, and though we are equal, some equality is not applicable. That is Article 14. Equal treatment is not given, therefore Constitution gives you a right to say that I must be treated by all authorities equally, and same protection should be given to me. Then Article 16. Article 16 has much debate and a good for advocacy, as advocates as our fraternity. Article 16, nobody should be discriminated in the public employment, regardless caste, creed, etc., etc. Everybody should be treated equally. Which rider? Same article says that government can make provision for reservation. So when you see Public Service Commission ads or local bodies advertisements, there is percentage fixed for each caste, community, etc. That is under the statute. And that's how Article 60, rate with statute, gives protection to unprivileged class of people to appear and compete with others. There is age relaxation. There will be relaxation in mark because you are under that reserve category, etc. But that is where constitutional rights protect these people. This caste must come. We must give them hand and make them stand. After 75 years of democracy, if somebody is unprivileged, then democracy is not successful. Then Article 19. Article 19 is also a very important article for the purposes of our freedom, our fundamental rights. Now there is a dispute, Hindi पाहिजे का लोगों तीसरी भाषा वगैरह, this all right. But Article 19 gives right to every citizen to speak, to adopt any language of his choice. He can profess his business or practice, medical, advocacy, etc. in any part of the India. So that 19 has given protection for your carrying on your activities, maybe your employment, maybe your profession, maybe your business, maybe your industry. That is under Article 19, it is protected. And freedom of speech is one of the freedom, the protection, fundamental right granted to the citizen. So what is that freedom of speech? Freedom of speech doesn't mean that you go on insulting somebody or abusing somebody. Freedom of speech is where you have fair criticism on any issue, on any individual. Just like contempt of court, we say that High Court judge matters are criticized. Even in public debate, you can criticize the High Court judgments, but when you are criticizing, you don't cross your Lakshman Rekha, you restrict yourself to your legal branch, and you say that because of this law, these provisions of the statute, the judgment suffers, is vulnerable to attack, and therefore Superior Court should take cognizance and set aside that. Then Article 21. I am giving this is a litigation in the High Court you have to conduct. Article 21 is protection of life and liberty. There is a lot of litigation on this article, means taking aid of this article. To be case which Olga Kelly's first case decided by Babu High Court, to which I was party as a junior advocate appearing for Olga Kelly's, and my senior Mr. M.A. Rane was addressing. In Bombay there is a Tulsi Pipe Road which connects Mahalakshmi to Mahim. So for airport they wanted a free way and they wanted to clear the footpaths. Case was argued before Lentin, Justice Lentin. And he was requested to visit the site, and he visited the site along with advocates and police officers and government machineries. At that site he found there are newly born children, there are old age people, it was raining slightly. There he stopped the eviction and said that you can't evict them unless I decide. Then matter went to Supreme Court, and Supreme Court went ahead and said to reside on a footpath is your fundamental right. Why? Because government has failed to provide you a decent house or accommodation to stay. On that there is a debate whether education is a fundamental right. Yes, Supreme Court has said to have education is also fundamental right. So suppose somebody is denied admission, I am not talking about fees etc. In general I am talking. Your student is on merits, but he is denied admission. You can file writ under Article 226 and say that he is denied opportunity to get admission and study the branch he wants to learn, and therefore this is a violation of Article 21. Then there is, for human being, only food, clothes and housing is not sufficient. He should have other infrastructure for healthy family. And that's how Supreme Court has responded in such an extent that you can bring anything under Article 21. To have decent housing, to have education, because under that there is this government has come with the scheme of free education, of etc., etc. Many schemes of the central government and state government functions on that. So protection of life and liberty, this is one of the major issue argued in the High Court. Hawkers for a case. Whether hawkers have a right, fundamental right to hawk on the street and disturb the public, whether they can encroach the footpaths and roads. The Supreme Court has said, by regulating their activity, you should permit them to hawk, do their business, because if you deprive them of their business, they will have to die without food and shelter. They can't support their family. And that's how Article 21 was extended to aid these people. When we feel, I also feel, why they are not following the law, why they should be given protection. But other side of the coin is that basic amenities are not available to 70-60% of the population. Education is not available. Houses are not available. And employment is not available. There is a failure to say so, because when we see that, I was also surprised that postgraduate students are applying for full job. Means there is something wrong in our education system also. But apart from that, these are where Article 21 will come in picture, and there are various litigation debates on this issue. Then important is Article 1 is Article 26. That gives the right to you to profess any religion, and for minority religious communities, protection is given. So when you find minorities, schools, colleges, and restricting the intake of the admission and giving some percentage to their own community, like Mohammedan, Jain, etc., etc., this is under Article 26, because they are small communities. That's how Article 26 is a very large debate on Article 26 which is happening. But this is one of the issues which is also coming in the High Court regarding medical admissions, regarding engineering admissions, etc., regarding this recruitment of the professors, lecturers in the minority institutions, etc. The litigation is in the court, but there is a very limited scope for the High Court to interfere. When I say there are 5 types of writs, now we have to see what is the meaning of writ, because this is a basic thing which you must know. When you say that 70-80% practice of the High Court will be in the writ, either in writ 226 or 227. So writ is derived from the old English word written, meaning is to write. In English course, that power is with them from 1200, 1300 centuries. First time in India, East India Company through King George I in 1726 was given a power. The Supreme Court at that time established at Calcutta. It was called as Supreme Court at Calcutta, that is Supreme Court at Fort Williams. That was called, and writ jurisdiction was conferred. So the judge has a command, has an authority to say that, all right, Mr. Queen, you have detained these citizens illegally, release them. That's how the writ jurisdiction is. Then and why it should be issued. One, usually used for illegal detentions. We go to the court on behalf of the client, telling the judge that so and so is illegally detained. Somebody else is filing writ petition on his behalf. Maybe his family member, maybe his friends, or maybe his social workers. Well, that man, you don't know where he is kept by police authorities or by the government. So you go to the court and say that this man is kept by them illegally without following due process, and issue a writ of habeas corpus. Habeas corpus means produce the body as it is in the court. This many cases recently has happened in the family matters. For children, minor children, when parents take away in violation of the court's order, etc. Sometimes this also is writs of habeas corpus are filed to get back the children. That's how habeas corpus is. One incident I must indicate of my junior days in emergency. Writ was filed of habeas corpus by my senior of Pramila Dandavati and Munal Gore. Their detention was set aside by the High Court, and they were to be released from Arthur Road. And I was witness to this, and along with their family members and social workers, I went to Arthur Road for completing the formalities. We came outside by small gate along with these two ladies, and they were taken and kept in police jeep and taken away. Next day we moved the High Court saying that you release them, but they are again illegally detained them. At that stage, matter was heard in morning, and police were directed to produce these two ladies in the High Court. And from there they were released. That's the power of writ of habeas corpus. Even in emergency, that was used by the High Courts. Very few High Courts use it, but Bombay was one of the High Court which used it to protect the civil rights, civil liberties of the citizens. This is a litigation you have to face as an advocate. So you must know what is the habeas corpus, what is the power with that, and it lies with the court. Then there is a mandamus. Mandamus is a command to do certain things in a particular manner, and that can be issued against only government, semi-government, and the authorities who are discharging public function under Article 12. So mandamus is a litigation which is regularly prayers, must have been seen. We pray that writ of mandamus should be issued against so and so secretary, directing him to withdraw his order or JR and do these following things, etc., etc. So mandamus is a writ which is regularly you have to deal with in your High Court litigation. Then writ of prohibition. Writ of prohibition is to prohibit something to happen. The courts can issue writ of prohibition saying that so and so, mister, you don't do this. That is injunction. Writ of prohibition means injunction, but it is called writ of prohibition to prevent certain acts to be done, which courts feel if permitted to be done is illegal or violative of fundamental rights, violative of constitutional rights of the citizen. So writ of prohibition is one of the issue, one of the writ which is required to be dealt with. Then fourth is a writ of certiorari. Certiorari is where Article 2 to 7 comes in picture. Generally single judge dealing with the writ petition under single judge, Article 2 to 7, issues writ of certiorari. It can be issued against the lower courts, it can be issued against the tribunals, it can be issued against quasi-judicial authorities, it can be issued against any authority who is discharging quasi-judicial function. So writ which I mentioned, I have mentioned that writ petition in the Cooperative Societies Act, Industrial Law, etc., etc., all are writs under Article 2 to 7. Scope of Article 2 to 7 is to see whether the courts below, tribunals below have conducted themselves in a procedure established by law, and their decision arrived by them is within the ambit of the powers given to them. So one, whether natural justice are followed, whether provisions of required, suppose cases from civil code, whether civil procedure code and other enactments are followed, etc. So jurisdiction of the writ certiorari code, where major litigation is there, has to be, you have to find out what is error of law apparent on the face of record. So you keep this in mind, error of law apparent on the face of record. That's how you have to place your submission, saying that my lord, this is the error of law apparent on the face of record, and this is my submission. Then only court have power to entertain your writ petition and grants the relief as prayed for in the writ petition. Various tribunals are functioning, as I have given you, 12 or 13 tribunals are functioning, which has appellate jurisdiction, where writ of certiorari is very important. Then there will be writ of quo warranto. Writ of quo warranto litigation is not much. Quo warranto means some public office, some statutory office is held by some person. Suppose I am aggrieved and I was of opinion that I am entitled to that post, but somebody else has been appointed by government. You go to the court and say that issue quo warranto. Quo warranto means the respondents are called upon to show the authority of law under which that chair is occupied by him. So that is a quo warranto. That litigation is not much, but a important writ jurisdiction as far as the high courts are concerned. So when you practice at appellate side, you must know which matters will go to writ jurisdiction, which matters will come to the appellate jurisdiction. Appellate jurisdiction is mainly writ of certiorari. Original jurisdiction under Article 2 to 6. All writs are entertained like habeas corpus, mandamus, prohibition, quo warranto. How to conduct original writ petitions? Original writ petitions means petitions filed first time in court of law, not 2 to 7. Because 2 to 7 you have tribunal judgment, civil court judgment, etc., where you file writ. This is a writ of original jurisdiction, we call it. In plaint, you plead facts. You don't plead evidence. Some cases you plead law. And civil suits are tried and decided on ocular testimony and documentary evidence proved before the court. So it is a oral evidence, it is a documentary evidence which will decide the fate of the case. Plaints are affirmed on oath. Contains in the plaint, deponent says that I am aware, I am advised, these are legal submissions, etc., etc. When the writ jurisdiction, evidence is not recorded. So when you prepare a writ petition, you have to keep in mind that you have to give the facts, and that facts should not be disputed questions of facts. You have to take a care, that is a draftsman's skill, to avoid disputed questions of facts. We have to give first what are the facts of the case. We start with it, who is the petitioner, first para, who is the respondent, ABCD, 1, 2, 3, 4, who are these respondents, and third para will be why you are approaching this court. and fourth para onwards will start facts. Then you have to plead evidence. And when you plead evidence, you go on annexing the documents. And you say that document annexed at Exhibit A is true to my knowledge and belief. So you take oath about the veracity, genuine of that document. Then law. We have to plead the law. So when you file a writ petition, not only you plead on facts, you give evidence in support of that, and you give law in support of that. Many judges read and come. If you are, by reading your petition, if they feel that other side is required to be called upon to answer, within a minute or two, notices are issued. Otherwise, it takes some time to persuade the judge to issue notice to the other side. So, suppose notice is given and other side represents. In civil suit, he will, as a defendant, he will file written statement. And he will say, I will see when document production stage will come, when exhibition will come, when I will cross-examine, then I will see what documents I should give. When you file your affidavit in reply, you have to also plead your case, give documentary evidence and law on which you are reliant upon. Then there is a rejoinder. It is now by practice is a matter of you are entitled to file rejoinder, because suppose new case has come up in the affidavit in reply of the respondent, which you want to explain or meet or give your answer. In that rejoinder is permitted, so that case will be decided on your writ petition averments, we call it pleadings, written reply of the respondents and your rejoinder. So procedural part is totally taken out of it. When I say procedural part is taken out of it, means there is no need to say that this document is proved, not proved, etc., etc. You annex it unless court has suspicious, will rely upon that document and grant relief depending upon facts of each case. So writ petition is a weapon to protect the civil rights of the parties, fundamental duties, and give justice to downtrodden. So writ jurisdiction drafting is in detail required, all facts must be pleaded, all evidence must be pleaded, all law must be pleaded, so that you get at one place everything, because subsequently you can't give the document across the table. Well, that other side will say that I don't know which document he is giving. So to avoid that, generally everything is given in the petition form, in the affidavit reply form and rejoinder form. And on that basis cases are argued. So writ jurisdiction in the Article 2 to 6, care has to be taken about the pleadings. Other 2 to 7, entire material is there from the tribunal courts, by civil courts. So you can say that suit was filed or the cooperative dispute was filed, trial court decided this, appeal court decided this, I am before it, and ABCD grounds, this is error in the apparent on the face of record in the judgment. So doing so, you take a care that writ petition under Article 2 to 6 is a total different litigation and has to be taken very seriously, because it affects citizens, all stakeholders in that class. Now, what are the powers of High Court? At one district place, I was asked question by one advocate, why powers of writ jurisdiction are not given to the district courts? Naturally, there is nothing wrong in posing that question. Then that power is to be exercised, and the exercise of power can't be distributed in such a manner that government becomes vulnerable. These are under the law charters, Latest Patent Act and Constitution as framed and came into force from 1951. So High Court is exercising constitutional powers, and that powers are not given by constitution to the district courts. There is a difference between High Court and district court. So High Court is a constitutional court. Therefore, we say that High Court is a constitutional court for the Article 2 to 6. In High Court is also major issue, important issues or litigation is election petitions of Assembly and Parliament. I must indicate one case of Indira Gandhi versus Raj Narayan, where Indira Gandhi's election was set aside in 1975 or so by Allahabad High Court by Justice H.R. Khanna, and she was prohibited from contesting election for 6 years. See the power of the High Court, single judge of the High Court sitting at Allahabad, to say that Prime Minister, your election is set aside by me, and next year, 6 years you can't contest the elections. Even Baba Thackeray was prohibited from contesting election in Dr. Prabhu's case for 6 years. That is the power of the Constitutional Court. That is the power of the High Court. High Court judge sitting singly can set aside the law framed by the Parliament or framed by the Assembly. That is the power of the High Court judge exercising writ jurisdiction. To say so, recently in America, Honorable President Trump passed some order of migration, etc., etc. Some court, district court somewhere has given injunction. That is the power of the courts, that they have power to stop president for implementing his own decisions. That's the power of the High Court judge, to stop Parliament or Assembly from violating the fundamental rights of the citizens. When emergency was declared, petition came whether you can suspend the fundamental rights. Many of you may not be knowing, newspaper used to come, front page, half page was blank. Because earlier day, government officers will go and scratch that from the print. So newspaper will come half blank and half news, which is not relevant. As ha mela hai, udak teji sabda hai, that is the news. Nothing about government. That is the freedom of speech taken away during this emergency. Matter went in Supreme Court. And in the judgment, which is very important judgment, it was majoritarily held that in emergency government has power to suspend your fundamental rights. And H.R. Khanna, as a Supreme Court judge, gave dissenting judgment saying that even in emergency you can't take away freedoms of a citizen. Argument was advanced by Attorney General before the Supreme Court. If government wants to shoot anybody, just will go and shoot him. For that, no permission is required. That passage of time, that judgment proved to be incorrect. Some judges who delivered their judgment said openly that was mistake committed by us. So emergency was a test for High Court to stand for the civil liberties of the citizens. And you as an advocate, I as an advocate, perform very important part in protecting freedom of liberties, fundamental duties, etc., which are given by the constitutional courts. So this branch is generally not touched by the advocate practicing in the trial courts, because that is not necessary for them to do so. I will just give illustration. You must read these judgments. I will give the citations. From that you will find, and as you will be practicing in High Court in near future, you will have things are happening good for us. We will be able to practice in the High Court in near future. So you must don't wait till High Court comes to your door. Be ready to handle the High Court. Be equipped to argue the cases before High Court. And nothing extraordinary. I also studied from Shahji Law College. Nothing. The law is in books. how you read it, how you present it, how you mold yourself is your own personality. Keshwanand Bharti versus State of Kerala. This judgment is the foundation of our constitution, where Supreme Court has said basic structure of the constitution can't be altered. What is that basic structure? Article 14, Article 19, Article 21, Article 26. These things can't be taken away from the citizens. Then case comes to Maneka Gandhi versus Union of India. Maneka Gandhi's case is important as name is familiar to all of us. After emergency, passports of all Gandhi families were seized and taken away by the government. And Maneka Gandhi's case, it was cancelled. So they can't travel outside India. Government maybe at that time thought that they will leave India and they will not be able to stand trial if they have to be tried in India. Maneka Gandhi went to the Supreme Court and said that my passport is taken away and that is by violation of Article 19 and 21. Freedom of movement given under Article 21 and Article 21 is, Article freedom of movement Article 19 and Article 21 which gives you right. This is a woman passport. It may not be for all, but for some people, for industrialists who travel all the time for outside India for business, passport is must for them. Such like the court has said that when, note my word, when there are civil consequences of any action of the government, then natural justice must be read. What is that natural justice? Natural justice depends upon facts of each case. So in case of withdrawal of passport from Maneka Gandhi, she should have been told by giving notice that madam, for ABC reason, I want to suspend and cancel your passport. Please explain. She will give explanation in writing. That may be considered, can be overruled, and passport order can be passed. She may ask for oral hearing. Party, he or she can ask for oral hearing. That depends upon facts of each case. In generally, courts have said that hearing is a must. Justice Bhagwati has said in Olga Telly's case, if I am not wrong, that there is a human touch when you are arguing before the judge. You are standing in front of 10 feet or 12 feet away from the judge. And you can see in the eyes of the judge, justice in the eyes of you, eyes of the litigants. And that's how human problem, human approach of the judge will change. And therefore hearing is must. So why you go and argue? It's not empty formality. A human being is sitting there, he has many strong weaknesses in his character, and not to quote me outside. Then you argue the case depending upon that judge. And that's how oral hearing is necessary, and the Justice Bhagwati has said so. Why that is important? Because human touch is lost if oral hearing is not given. All these branches you must know when you are practicing at writ petition under Article 2 to 6. Then third is Vishaka versus State of Rajasthan. What is Vishaka? A sexual harassment case went from government department up to High Court and Supreme Court. And there was no internal mechanism to find out truth, punish the wrongdoer, take departmental action against the wrongdoer if that complaint is correct. Because nowadays, women participation in all the fields is increasing. I am told that the ladies judges, lady advocates are also asking for this in the Bar Council of Maharashtra. It has to come. So what is Vishaka? Supreme Court said that all government, semi-government organization, etc., like municipal corporation, council, Jilla Parishad, wherever, banks, etc., there should be internal committee which is headed by lady officer and that complaints will go to her. It will be tried in a closed room, and justice will be given that woman. That is a Vishaka's case. From that, total difference has come, and all government authorities, government etc. are having internal committees. That's how Supreme Court used that word, used its power, and judgment of Vishaka has changed a lot for the benefit of the women employees etc. working in the government establishment. Then Puttuswamy's case, Puttuswamy. These are basic judgments I am giving, and from that law is developed. Right of privacy is stated as a fundamental right under Article 21 of the Constitution. So, how Article 21 is explained by the Supreme Court and High Court, and you have choice to expand it on your own advocacy skill. Keshwanand Bharti case, Maneka Gandhi case, Vishaka case, these are the first judgments given by the Supreme Court. Thereafter there is law again taken up forward by the High Courts and Supreme Courts. The Puttuswamy's case Puttuswamy, right to privacy as a fundamental right under Article 21 of the Constitution. So I have a right to privacy is Article 21. So just see what extent your writ petition can contain. Then State of Bihar versus Kamleshwar Singh. A concept was used, what is a doctrine of colorable exercise or colorable legislature. In that, Supreme Court has said this can be tested under Article 14, 19 and 21, and it is colorable, that act should be struck down. So you also see what is this State of Bihar versus Kamlesh Singh. Then Ravindra Jain versus Union of India. This is an important case for you for laches. What are the laches? What is the meaning of laches? As I told you, in a writ jurisdiction power of the High Court under Article 226 is unlimited. It's open to sky. There is no filters. But there are self-imposed restrictions put by the Supreme Court and High Court in its exercise of that jurisdiction. So laches. So when you are taking a cause to the Honorable Court, is important for the purposes of laches. As a civil suit, you say what is the cause of action, there is one clause. Limitation, there is one clause. Therefore, writ petition also there is one clause. That petitioner has approached this Honorable High Court as early as possible. Cause of action has arisen on this date. Writ petition is filed today, therefore it is within time. So laches is one of the issues which is generally looked into by the courts. Many cases, people unable to approach the High Courts or superior courts, I will put it. For them, this laches is diluted. So what is the laches? Just that sees. Then Tikaramji versus State of UP. That is a judgment will give you idea what is the doctrine of harmonious construction. As a writ advocate arguing writ or constitutional point, it is one of the issue involved how harmonious construction can be put to that legislation, to that section, to that particular sentence or to that particular word, without striking down the statute. To save the statute, but you construe the statute in such a way that it doesn't affect Article 14, it doesn't affect Article 19, 21 or 26. That is harmonious construction. That is a skill which a writ petitioner advocate has to adopt, and by passage of time, by experience, you will get it. Then State of Bombay versus FN Balsa. These are some words which may not be familiar. Established doctrine of pith and substance. These are where there is no evidence laid. So doctrine is explain what is pith and substance. Some advocates use this word in their petitions. In pith and substance, this is my case. So that judgment will give you an idea what is pith and substance. While drafting it, you can keep it in mind that by taking advantage what law judges have said, you can use this judgment to formulate a question of law, formulate a factual position, to give it to the Honorable Court to show that there is something which Honorable High Court has to look into. Then Tata Air Steel case versus State of Bihar. Established doctrine of territorial nexus. What does this mean? High Court of Bombay can issue a writ to authority within the state. Some cause happen in Karnataka, Gujarat or Madhya Pradesh can't be brought to High Court of Bombay because Bombay High Court will have no territorial jurisdiction. Supreme Court, yes, throughout India, the High Courts as per the territorial jurisdiction conferred upon the High Court. So that is where Tata's case was considered. What is the territorial jurisdiction? For that judgment will be of some use to you. Then RMD Charbugwala, State of Marshal. Charbugwala spelling is CHARBEAUGWALA versus State of Mysore. That judgment has given aid to the High Court to come to the aid of the citizens. That is a doctrine of incidental or ancillary powers. That is invented by the judiciary apart from these 5 writs. So I have ancillary power, I have incidental power, I will correct the injustice where it has happened. That's how the High Court judge has to look into it. And then fundamental right case, I told you, Article 21. Right of education is a fundamental right. Why it is said so? If you are illiterate, you are not human being. There is no difference between you and animal. Education is a must for every individual. And in that fashion, in case of Mohini Jain versus State of Karnataka, Supreme Court has said right to education is a fundamental right. And in that context, central government and state government has come with the schemes that free education will be given, midday meal schemes. All these things are happening because of this judgment. You will be surprised because I have conducted in case of High Court regarding midday meal. 13 lakh students, crores, 13 lakh students are taking food, free food from this government. So see the impact of the judgment. 13 crore students can get benefit of this midday meal. Unique system in world. Maybe there are some irregularities which are happening on the ground level. But in fact, it's a success. Even it is reaching to 80-90% of students. Out of that, what the central government has said, that out of 13 crores, 18-19 people, students are getting midday meal. This is sufficient to say that the judgment has given effect and helped these 1,200-1,300 crore students. Then we come to PIL. PIL is a weapon. It is used widely in the courts. You will have to handle this litigation. Is PIL is blind bullet fire in the dark. By blind man, bullet fires in the dark. It started with a postcard sent to the High Court, which was treated as a PI litigation. And if I am not wrong, that in Khatun versus State of Bihar, 40,000 prisoners under trials or after conviction were set at free because they were undergoing inhuman treatment. Food was not available, space was sleeping space was not available. There are no facility of taking bath, giving answer to natural call, etc. Everything was nil. In that context, Supreme Court said that you release these 40,000 prisoners. That's how the law has developed, that even under trials, convicts have also some fundamental right within themselves. In Corona period, that was exercised and many detainees were released on bail. Outside, we say that as a High Court advocate, you must know, therefore I am giving this reference. Many 1,000 crores scams happen in India, and that gentleman goes and stays at London. And London court says that no, I can't repatriate you. Government demands are rejected. Why it is happening? Their conception of Indian jails is that it's not a human livable place. That's how one retired High Court judge has deposed in the London court. That's how many of my friends who are practicing this field and have gone and deposed in London courts about giving the what is in that prison. Therefore, there was one article that give Vijay Malla a air-conditioned room in the jail and attendants to attend. But outside London, because we are all laws colonial based, why we say we quote London laws, we quote Australian laws, we quote in English American laws. Why we do so? Because our jurisprudence is same. So London court says that Indian jails are not fit for human beings, therefore we will not permit their taking away from London territorial jurisdiction. That's how they stay there and they enjoy their life there. I have seen something, they are also dancing that I have done, the government of India, nothing can be done to us. That's how I am giving you an example. What is the fundamental right? To have basic food, sleeping place, etc., which is not available to the prisoners. Even in Colombo jail, Arthur Road jail, any jail you go, it is full packed. Capacities, they are beyond their capacities, treating the or holding the inmates or the, that's how that Khatun case is a first case where judiciary intervened and released these people. Then S.B. Gupta versus Union of India. This case permitted a public spirited citizen to come to court by way of public interest litigation. So court, you can bring any issue as a public spirited citizen to the court and point out to the court that something has wrong, something is not happening in accordance with law, there are violation of fundamental rights, etc., and you intervene. Then there is a judgment of M.C. Mehta versus Union of India. You must note this judgment. M.C. Mehta was a practicing advocate in the Supreme Court, and he took up a lot of issues, environment issues. Mainly he was concerned with the environment, where one central minister constructed a bungalow in the river in Himalaya Pradesh, that state, and diverted to river flow. It's famous judgment. And Supreme Court says that all right, you have to remove that bungalow and you have to restore that river path, and damages were granted against that minister. It's an old judgment, but that's how the public spirited citizen came to the court and pointed out that something illegal has happened and you intervene. Recent case, I think, from case of elephant from Kolhapur district is to be transported somewhere at Jamnagar or somewhere. That is, I think recently I was in one court and that case was argued. Of elephant, even though for animals, these causes are taken. And courts do intervene. Therefore, you should be equipped. Don't wait till High Court comes to your door. Equip yourself that what litigation I have to address, for what I have to prepare myself. It will not happen in a day or two, but attempt has to be made. You have to start, and it should not be tomorrow. Where always there is tomorrow. Start from today. This is what, once High Court comes, it should not happen that you are ill-equipped to deal with the litigation which High Court is supposed to deal. Second appeal, first appeal is not litigation which High Court is supposed to deal. It's a court of appeal. But High Court is supposed to deal the cases of this nature, of rape, constitutional rights, all these tribunals, etc. So you should equip with these cases. And when I say that these are the judgments which I have given, are first time Supreme Court has interpreted. And thereafter Supreme Court has taken it to extreme end also, saying that what is fundamental right under Article 21? Education, can we imagine that education can be fundamental right? But they say that without education he is an animal, creature, not a human being. Therefore that is a fundamental right. And in that context you have to read these judgments, and then you will understand what is writ practice. What is the meaning of advocacy in the writ jurisdiction? And that is where your skill lies, and law has to be very perfect. Evidence Act is not applicable. Your CPC is not applicable. No rule of procedure is applicable. In PIL there is nothing is applicable. It is between court and the wrongdoer. You have to just point out that this is wrong committed by this authority or this government functionaries. Then a landmark judgment who want to practice at service law. Indira Sahani judgment versus Union of India. A case came where reservation was going beyond 50. In some cases it went up to 82%. So what is remained with the general class was 18%. There are horizontal reservation, there are vertical reservation, there are reservation for freedom fighter, there are reservation for athletes, Arjuna awardees. All reservations are available apart from caste and creed. In Indira Sahni's case, they said that reservation should not exceed 50%. That's how that judgment stood. That law declared by the judgment is still good law. Maratha reservation case, I was appearing for the state of Maharashtra. We succeeded in High Court, but Supreme Court struck it down on the ground that it is exceeding 50%. If Maratha reservation is granted, already Maharashtra has 52% reservation, 16% will be added, it will go to 68%. And that's how Indira Sahni judgment will not permit you, and therefore Supreme Court struck down that law. So Indira Sahni case, those who want to practice, you must know what is Indira Sahni's case. Nobody is able to dilate Indira Sahni till now. In Maratha reservation case, we argued that reference should be made to the larger bench because Indira Sahni case doesn't lay down correct law. That request was rejected by 5 judges court bench, saying that we accept Indira Sahni as a correct position of law and we reject your argument. There is no need to reference to the larger bench. Larger bench, High Court, I will just indicate now High Court, what is division bench, what is High Court, larger bench, etc. High Court, there are division benches, there are single judges. Depending upon High Court appellate side rules, original side rules, matters are placed before single judge and division bench. Second appeal, CRA or writ petition under Article 227 will go to the single judge. Then division bench first appeal, criminal appeal against conviction of 302 or 307, etc., goes to the division bench. So also, writ against the 226, writ first time goes to the division bench. Single judge, it regularly happens. Single judge will find that there is a conflict in two division bench judgments. One division bench has said so, the law pronounced by them is this. Another bench, by ignorance of that judgment, I am putting that word ignorance because may not have been cited before that bench. Ignorance of that judgment has said something which is contrary to that proposition of law. So, what the single judge is supposed to do? We regularly argue that is now there is conflict in division benches. You refer the matter to the constitutional bench. Sorry, full bench. Full bench. That is a 3 judges bench. Generally 3 senior judges sit in that bench, and such type of references are made to the full bench and matters are decided. Then law declared by full bench subject to Supreme Court will be final and binding on the state of Maharashtra. Then comes to constitutional bench, it relates to 5 judges. There are very few occasions in the High Court where 5 judges are sat together and decided about the validity or etc. Generally, cases of validity of any legislation, etc., or cases of very public importance are placed before constitutional bench. In my practice, I have seen 3 or 4 full benches, constitutional benches of 5 judges constituted, and in main court, courtroom number 46, they generally sit and they decide the case. In Supreme Court, 2 judges or 3 judges sit as per convenience. They are treated as a division bench. Only because 3 judges have decided something, it will not bind 2 judges, but 2 judges can take different view and refer it to the larger bench. Then there are 5 judges bench, 9 judges bench, 11 judges bench. So that's how the courts are constituted by the Chief Justice depending upon the gravity of the case, etc. And very public important cases, these matters are referred to constitutional benches of 5 judges, 9 judges, 11 judges. You will find in medical matters there are judgments. Prime is, I think, Pay Foundation case. What Pay Foundation case said in 9 judges, by 9 judges, was explained by 5 judges, and why 5 judges said was explained by 2 judges. So that's how the benches function. Issue will be which branch you want to practice. Start equipping yourself. Start reading Constitution. One way I am told that what is difference I have to tell, therefore you should not take it that I am saying something. In our days when we started practice, the High Court judges used to call us in chamber and they will inquire with you what you are doing, from where you have come, and they will tell you how you are reading the law. Keep the notes, keep the notebook, read important judgments and keep it. And that's how we were encouraged by the High Court judges. One judge, I will not name him, in April, before May vacation, I was only 3-4 years junior at that time. And I thought that High Court judge has called me, I told something wrong, I have committed something. We were afraid. Even in court also we feel there is a distance between you and High Court when you are junior. High Court judge when you are junior. Then along with there were 10-15 advocates like me. And तू का आलायस मला वरती बोलवले ठीक आहे चलो. Then he said that what your father is doing, what your father is doing. Then he said that the Kandapur वगैरह आले, we had that. Then what you will be doing in May vacation? What was question mark? What will you do in May vacation? It is a vacation. He specifically told me, Sakre, your father is advocate. He must be having library at his own. I am giving you indication what he told me and what you should do. He said that take one subject of res judicata, read it from 1950 Supreme Court till date. In your life you will not require to open that book again. Take one subject and finish that subject in 2 or 3 days. Within 30 days, 15 subjects you finish. So what is my request or advice to you is, start reading what is Article 226 and Article 227. Don't wait, devote daily 2 or 3 hours. Juniors can't spend. सिनियरला सांगायला लायब्ररी जाऊन बसतोय, तुमचं तुम्ही बघून घ्या, मला हे वाचायचं आहे. That's how we were told. And he said that all right, from 9 to 1 o'clock, 4-5 hours you spend. Other who is not having libraries at their home, first time advocates, they said that from which district you are, I will tell the district judge to make your district court library available to you for reading. Go and read there. So daily 5 hours, 30 days, so 150, 150 तास आम्ही वाचलं. Then it became a habit to read the books. We till recently used to subscribe for Maharashtra General, Supreme Court cases, Bombay cases reported, etc., industrial law reports, etc. Now people have stopped because that soft copies are coming. But we used to read it and we used to note down the law which is important. In each books we will find something which is relevant for which we practice. You read library, search in that your laptop is very easy. You put the question, even Meta also you will give answer. I put one question to Meta, he gave me answer, and his last sentence was, you consult legal expert on this. So we in the court is still there to go and outside. So I put the question to Meta, so queries of the court. I said that this is a query and put that. He gave me the answer. Last sentence was, please go and consult a legal expert. So this is artificial intelligence will be of much help to you. No doubt about it. No doubt about it. Your labor in search law, to search law is very much minimized. You can pinpoint your queries, you can formulate your questions, feed it, law will come. But personally I feel that you as an advocate must know law when your clients come to you. Not after client comes to you, you start searching the law. Many times client will come and give facts. You must be ready. हे जजमेंट आहे, हे जजमेंट आहे, ह्याच्यातून आपल्याला क्लायंटला आपल्याला बाहेर काढता येईल. विल सक्सीड. दे डोंट गो ऑन सर्चिंग. हिज क्वेरी आहे, हे असं आहे, काय करू. सो रीड द बुक्स. दॅट इज इम्पॉर्टंट. देर कॅन बी सबस्टिट्यूट. आय फील इन माय चेंबर देर आर 4-5 juniors. If I tell something, they go on searching. I want to search कशा करायचं. Just see that judgment is there. Justice Gajendra Karkar has decided in 1961-62. Go there, you will find it. So some judgments you know by heart. But as an advocate practicing in High Court, there are 2 types of High Court judges. I should not be quoted outside. I will disown him. One is direct recruitment, elevation we call it, from the bar to the bench. And one is from lower judiciary. Lower judiciary are equipped with the trial. They are very good in the second appeals, first appeals, criminal matters, etc. The elevated advocates, those who are elevated from the bar to the bench, are good in the constitutional laws because they have handled that type of cases, litigation as advocate, and they can therefore have grip on the issues and decide the cases. After passage of time, everybody has a knowledge. Even lower judicial people also are equipped. They deal with it equally successfully. But when you practice at the High Court, you should be very good at law. You must, I will not say that at tip of tongue your judgment should be there, but you must know that this is the law of the land, which there may be queries coming from the court, and you can stop the judge by saying that what your lordships are saying is negated by the Supreme Court in this judgment, and just stops at that. So you have to learn law by heart, go to the library, sit 2-3 hours per day till High Court comes. By that time you will be equipped to deal with the High Court cases. I think that is what I feel the advocate practicing in High Court should adopt, should improve himself and be ready for High Court litigation, nothing extraordinary. By passage of time, everybody will be comfortable. When Aurangabad went in 83, bench was established, there was little bit some problem with the advocates to adjust with the High Court advocacy. But many advocates within 2-3 years were equipped. Now there are judges from Aurangabad going up to the Supreme Court. Nagpur, same thing. Nagpur was established in 1936, a long legacy. Aurangabad 1983, and we will start in near future. And I think that there will be occasion to celebrate of High Court bench at Kolhapur in near future. With this, thank you everybody. Thank you.
खूप खूप धन्यवाद सर. आपण अतिशय चांगलं व्याख्यान आपल्याला दिलं आणि कोल्हापूर जिल्हा बार सेशन आणि इतर सर्वांना त्याचा नक्कीच लाभ फायदा आपण म्हणतो तसं लवकरच नजीकच्या काळात होईल अशी अपेक्षा व्यक्त करतो. त्यानंतर कोल्हापूर जिल्हा बार सेशनचे सहसचिव सूरज राजकुमार भोसलेंना विनंती करतो त्यांनी आभार प्रदर्शन करावं.
आज या व्याख्यानासाठी ज्येष्ठ विधिज्ञ ॲडव्होकेट अनिल साक्री साहेबांनी त्यांच्या व्यस्त कार्यक्रमातून वेळ काढून आमचे कोल्हापूर जिल्हा बार असोसिएशनच्या विनंतीस मान देव आज या ठिकाणी आमचे सर्व बारला व बारच्या सर्व सदस्यांना आपले जे बहुमूल्य मार्गदर्शन केले, त्याचबरोबर आपले अनुभव जे आपण सांगितले त्यासाठी मी आपला सर्व बारच्या सदस्य कोल्हापूर जिल्हा बार असोसिएशनच्या सर्व सदस्यांच्या वतीनं आपले आभार मानतो. आपण जे मार्गदर्शन आम्हाला केले त्याचा नक्कीच भविष्यकाळामध्ये आम्हाला चांगला उपयोग होईल असं मी मानतो. आणि परत एकदा आपण आमच्या कोल्हापूर जिल्हा बार असोसिएशनमध्ये उपस्थित राहून जे आम्हाला मार्गदर्शन केले त्यासाठी मी आपले आभार मानतो आणि हा कार्यक्रम संपला असे जाहीर करतो.